My name is Patricia Wonder, and I want to welcome you to today's webinar, which is Winning a Marriage Case. We can move to the next slide. David's going to give you some information about some technical problems if you're having any.
Okay, thank you, Pat. Good afternoon, attendees. We encourage you to submit your questions related to today's topic to the question box in the control panel at the right side of your screen. We'll address as many questions as possible during the Q&A session at the end of the seminar. If you have any technical difficulties throughout this webinar, please call the number listed below, 1-800-263-6317, and press 1 for GoToWebinar, and then press 2 for technical support. Now let's get back to Patricia, who will tell you about our sponsors, CUNY School of Professional Studies and CUNY Citizenship Now.
Okay, thanks, David. We can move slides. We could change slides, please. And if I haven't received any chat messages from any of the attendees, so if you could someone please send me a chat. I just want to make sure everyone can hear everyone and there are no issues. So today's presentation will be given by two presenters, Victoria Donahue, who's of counsel of Nachman & Associates, and Noemi Mislia, who's a partner of Mislia and Soloway. We can change slides. Today's program is sponsored by CUNY Citizenship Now and CUNY School of Professional Studies. The website for CUNY Citizenship Now is cuny.edu/citizenshipnow. And CUNY School of Professional Studies is www.sps.cuny.edu. We can change slides. So CUNY SPS offers an Immigration Law Studies Advanced Graduate Certificate Program. Courses include Introduction to Immigration Law, Business Immigration Law, Family-Based Immigration Law, Proceedings in Immigration Court, and Naturalization and Citizenship. If we could move slides. For more information on CUNY SPS, please see the website sps.cuny.edu. We can switch slides. Another sponsor is CUNY Citizenship Now. CUNY holds Citizenship Now events across the city. The goal of Citizenship Now is to help eligible individuals prepare their Forms N-400 application for naturalization. Most events are held on Saturdays. We can switch slides. CUNY Citizenship Now has immigration centers all across New York, and the organization offers free immigration services to all members of the community, CUNY students and non-students. We can move on. CUNY Citizenship Now has a volunteer corps who provides free naturalization application assistance at Citizenship Now events in New York City. Let's move on. If you're interested in volunteering, please complete a registration form at cuny.edu/citizenshipnow/volunteer. Continue. So today we'll be speaking again about winning a marriage case. Our first presenter will be Victoria Donahue. I just want to remind you to please start sending your questions as soon as you can, and at the end we'll have a question and answer period. Victoria?
Okay, hello everybody. Can I have the next slide, please? Today we're going to be talking about marriage-based permanent residence, or green cards. When I use permanent residence, it's just the more legal term for a green card. All right, so a foreign national can, in order to adjust status to a permanent residence, the person can marry either a U.S. citizen or a lawful permanent resident. But there's a big difference between the two possible procedures. Spouses of United States citizens are immediately eligible to immigrate or adjust their status without retrogression. Retrogression is just the fancy legal word for the backlog. Lawful permanent residents can also adjust status based on a filing by the spouse, but they are subject to retrogression and it's in some cases, in most cases, quite significant. So how do you find out just what the retrogression is? The visa quota allocations are announced monthly by the Department of State in a publication called the Visa Bulletin, and on the slide we have a link to the Visa Bulletin. So if we take a look at it, for January 2011, the category for spouses of lawful permanent residents, which is family category 2A, preference 2A, is January 8th, 2008. And this means that a visa is available for a spouse of a lawful permanent resident whose I-130 was filed before that date. So to look at this slightly differently, if somebody were to file an I-130 today in January of 2010, they would be looking at about a 3-year delay before they got the green card. Okay, next slide, please. Okay, so what is the standard in a marriage case? How is CIS going to decide if a person can get their green card based on marriage? Well, the legal standard is that it must be a bona fide marriage entered into by the parties not solely for immigration purposes. Okay, the marriage, you must continue to be married in order to get an approval. And now an approval is possible if the parties are living apart, they're separated, and the marriage is no longer viable, as long as you can show that it was entered into not solely for immigration purposes. But of course, you're going to have a more difficult road if you're approaching this as a separated couple as opposed to a married couple. Okay, we don't have any citations to the law for this legal standard because the legal standard is established by case law. Okay, next slide, please. Okay, during this webinar, we're going to have 3 poll questions. And what this is we're going to give you a hypothetical, like a mini fact pattern, and then we're going to let you choose between 3 answers. So you think it over, you make a choice, and then we'll talk about what the choices, what choices you made and what's the correct answer. Okay, so the first poll question is, Natalie's H-1B employment was terminated and she could not find another job. She had no viable immigration options. Her U.S. citizen boyfriend had asked her to marry him on previous occasions. She had declined in the past, but now she agrees. They get married at City Hall and move in together. Is this a bona fide marriage for immigration purposes? Next slide, please. The answers are A, no, because Natalie would not have married the U.S. citizen but for her immigration dilemma. B, no, because the couple did not have a religious ceremony. Or C, yes, so long as Natalie could prove that the marriage was not entered into solely for immigration purposes. Okay, while you think about the answer, I'm just going to recap the question. Basically, you have a person who was in H-1B status. She was terminated. She can't find another job, and she has no real options at this point. So she has a U.S. citizen boyfriend that she, in the past, has not been interested in marrying, but she now agrees really because of her immigration situation. And they get married at City Hall. Is this a bona fide marriage? Okay, can we close the poll? All right, so let's see what we have here. 38% of you answered A. Nobody answered B, which is good because whether the parties have a religious ceremony is completely irrelevant. They're only worried about a civil marriage. And 62% of you answered C. And of course, C is the correct answer. B is very tempting because it's accurate. She only married the foreign national because of her immigration dilemma. But that is not the legal test. The legal test is answer C. Okay. Naomi? I'm sorry, Noemi.
Thank you, Victoria. Okay, I'm gonna talk about what are the essentials for a marriage case. And the I-130 petition is the sine qua non of a marriage-based immigration case. It forms the basis of the case. And that Form I-130 is filed with the U.S. Citizenship and Immigration Services, the USCIS, by that U.S. citizen spouse or the LPR spouse seeking to classify his or her foreign national spouse as an immigrant. And that I-130 is filed with, obviously, a copy of the marriage certificate, copy of the proof of petitioner's status, be a U.S. citizen or an LPR, copy of a termination of any prior marriages, And those documents, of course, if they're in a foreign language, would have to be submitted with a translation. Also, the petitioner and the beneficiary must submit what's called a G325, which is a biographical information form, and a passport-styled photo. One thing that's not on this slide, if the case is being filed by an attorney, that attorney must file a G28 with that petition. Both forms can be obtained at both the I-130 and the G28 and the G325 can be found at www.uscis.gov. The filing fee for the I-130 is $420. The USCIS will examine all the documentation and hopefully approve the petition. Now, it's important to note that approval of the petition does not confer any benefit or status to the beneficiary. That requires a subsequent step, which might either be adjusting status or immigrating by being processed by the consular post outside the United States. Another piece of the case, it was when the beneficiary is adjusting status in the United States. That's that second piece, which can be filed concurrently with that I-130 petition. It is filed with the USCIS by the beneficiary seeking to adjust status. Must be the spouse of the U.S. citizen, or that, as referring to what Victoria was talking about, that petition must have a current priority date if the spouse is only a permanent resident. The applicant, the beneficiary seeking adjustment of status, must be in the U.S. after having been inspected and admitted or paroled. That's stated clearly in INA Section 245A. If not, he or she must be eligible under INA Section 245I, which is beyond the scope of this discussion. If the spouse is a U.S. citizen, the foreign national, the beneficiary, need not have maintained lawful status prior to the filing of the I-485. That is, however, a requirement for the spouse of a legal permanent resident. The foreign national beneficiary must have maintained lawful status prior to the filing of the I-485. This means having maintained valid non-immigrant status and have not worked without authorization. That form I-485 also may be found at www.uscis.gov. The filing fee is $1,070, and that includes the biometric fee. That I-485 is, next slide please, that I-485 is filed with copies of that proof of the legal admission, which is usually or the parole in, usually with an is evidenced by an I-94, proof of maintenance of status throughout, particularly if they are the spouse of an LPR, all passports used at entry and the most current passport, birth certificate with translation, again a G325 with biographical information, a medical report which is obtained from a civil surgeon designated by the USCIS, and that uscis.gov website can also help you find a certified surgeon by zip code. Photos, passport-styled photos, an affidavit of support, which I'll go into, filed by the petitioning spouse, and if necessary, by additional joint sponsor. And if the foreign national has worked and has filed income tax returns, copies of those tax returns should be filed if available. Again here, if the case is being filed by an attorney, a G28 should be filed, must be filed with that. A G28, it used to be blue, now it can be white. My office, we still do use blue, so to make sure that the USCIS sees that the spouses are represented by an attorney. I'm now going to talk about, next slide please, I'm now going to talk about the form I864, a very complicated form which is required in all marriages from the petitioner. And that is to make sure that the foreign national will not be a public charge. The petitioning sponsor must show an income which is at least 125% of the poverty line, which is published by the USCIS on Form I864P. Minimum income requirements based on the household size. If they're unmarried and live alone, it's a household size of 2, and that will be considered if the income alone is insufficient. If it is insufficient, joint sponsors may be permitted in order to meet the income requirements. Now, the joint sponsor must be a legal permanent resident or a U.S. citizen domiciled in the United States over the age of 18. All I-864s must be supported with evidence of income, which can be in the form of federal income tax returns and W-2s or 1099s, employment letters and recent pay stubs, bank statements and proof of assets. Both Forms I-864 and Form I-864P may be found at www.uscis.gov. There is no fee when adjusting the status for the I-864. Next slide, please. And now we're going to go into the second poll question, which has to do with the I-864. I'll read the question. Sam, a U.S. citizen, is an artist. He married Sophia, who's the foreign national, who is also an artist. Last year, Sam earned $15,300 and Sophia earned $16,208. They have no children. Sam's wealthy parents recently gave Sam their New York City apartment, which is worth $500,000. Is there a way to prepare an affidavit of support that will satisfy USCIS's requirements? Okay, the choices of answers that you must ponder are, next slide, A, no, Sam doesn't earn enough money. B, yes, and Sam's parents can serve as a joint sponsor. C, yes, Sam can file the I-864 showing his income and his assets, which would be the apartment. So while you think about the answer and make your selection, I'll reread the question. Again, Sam, a U.S. citizen, is an artist. He married Sophia, who's a foreign national, who is also an artist. Last year, Sam earned $15,300 and Sophia earned $16,208. They have no children. Sam's wealthy parents recently gave Sam their New York City apartment, which is worth $500,000, and Sam is obviously petitioning for Sophia. So is there a way to prepare an affidavit of support that will satisfy USCIS's requirements? We can now close the poll. Okay, none of you answered no because Sam doesn't earn enough money. That's right, because that's an incorrect, that would have been an incorrect answer. B, yes, and Sam's parents can serve as joint sponsors. 21% of you answered that. And C, yes, Sam can file with his income and assets. 79% of you gave that answer. Well, both B and C are correct. So, let me see, add it, 100% of you were correct. So now we'll move on to the next part of the presentation, which Victoria will tackle.
Okay. We're going to now talk about preparing for the adjustment of status interview. An interview of the couple is always required by USCIS. There's no way to get an approved I-130 in a marriage case without going through the interview. And when you think about it, the reason is pretty logical. Up until the interview, the CIS has not seen any people. They've only seen the paper. And they need to see the people in order to make a credibility determination so that they can decide whether they believe the marriage to be bona fide. And just as so you know, they're looking for things that some people wouldn't think of, like body language. For example, the theory is that when people are married, when you ask the couple or ask someone the question, the husband or the wife will slightly look at their spouse before answering. So they're looking for little cues like that that you and I might not even think about. All right, so the interview is usually scheduled by USCIS at the local office in the state of residence, and it's usually 4 to 6 months after filing, depending on the speed at which your state works. In New Jersey, they're moving pretty quickly, so you would expect after 4 months that you would be called for an interview. Now, because this is CIS's shot at seeing the couple and making a credibility determination, preparation is absolutely essential. I can't emphasize this enough. If the couple has an attorney, they should meet with the attorney. They should go through the case. They should talk about what's going to happen in the interview. They should prepare documentation. When I do this with my own clients, I actually go through a mock interview because we have a pretty good idea of what kinds of questions are going to be asked, and we go through it, and we make sure that we're set on the questions. And then there's documentation that's going to have to be brought to the interview, and that's all the originals of copies that were previously submitted. So, for example, if you submitted the copy of the U.S. citizen passport, make sure you bring the original of the citizen passport. And then you'll have to bring the evidence to establish the bona fides of the marriage. Okay, next slide, please. All right, so what is that evidence? All right, it's photos of the courtship and wedding. CIS loves pictures. And there's a lease or mortgage in both names and joint utility bills because CIS wants to make sure that you're cohabitating. This is a very big part of being successful in a marriage case. Medical benefits letter showing medical benefits for the husband and wife. And this is makes a lot of sense because let's say, for example, that the wife is the U.S. citizen and she's employed and her company gives health insurance benefits. In order for her to be able to add her husband to the policy, she's going to have to come up with pretty good proof to show her employer before they're willing to add a spouse, because clearly adding somebody is a big expense. So if CIS sees it that they've been added, that's very probative in showing that the marriage is bona fide. Okay, they'll be looking at bank statements from joint accounts, evidence of joint credit cards, canceled checks showing shared household expenses. This could be extremely important if, for example, let's say that one party owns the residence. Like a client I had owned an apartment in New York, and it had been gifted to him by his parents, so there was no mortgage on the apartment. And so the wife moved in with him. So it wasn't quite as easy as in other cases to show. He didn't want to put her on the mortgage, or on any kind of official documents. So it wasn't so easy to show that they were both living there. But because she had paid for large sums of the renovation, we were able to show canceled checks, and that was helpful. Okay, certainly if any children were born of the marriage, you're going to want birth certificates. And then I have here on the list affidavits from persons knowing the couple. This is less important where you have a lot of other evidence, and much more important where you have weak evidence. So, for example, if you have a couple that moved in with somebody's parents, for example, and they didn't have a religious ceremony, so they don't have a lot of pictures, maybe they couldn't get credit cards. The less you have, the more important it's going to be to have these affidavits from people who know the couple and can say that they are, in fact, a couple. Okay, next slide, please. Okay, so let's talk about the interview and what to expect. All right, so when you get to the local office, to the district office, you have to bring your interview notice, and you put the interview notice in a box that they'll have when you arrive, and what I should say is when everybody has arrived. So if you have an attorney, put it in when your attorney and both the husband and wife are present. And that will alert the officer to the fact that you're there and that he or she can call you. All right, and then they're going to bring you into the officer will call you and bring you into the office, his or her office. And, you know, this is not a court, but it is an administrative proceeding, and it can be a little bit intimidating to people. The officer, before you're even permitted to sit down, will ask you to take an oath, you know, to swear or affirm that the testimony or the answers that you're about to give are the truth. And then the officer will question the couple together, meaning both of them in the room at the same time. And the questions will concern two possible areas. One goes to the basic eligibility to adjust status. So if there are criminal issues, they're going to want to talk about that. Certainly, if there's a prior marriage where the U.S. citizen filed for a foreign national in the past, and then the marriage ended in a divorce, they're definitely going to want to look into that. if somebody entered without inspection, that'll be a subject of conversation. And then they're going to ask questions that go deeper into what the couple's relationship. So they'll ask about, for example, your first date, where you went out, when on subsequent dates, the name of your mother-in-law. Okay? And then they may ask questions about documents that were submitted. And so if, for example, you're married but last year you filed taxes separately, they may ask why that is. Okay, now this is an important point because this is fairly new. CIS has taken to looking in social networking sites. So anything that you put on one of these, like Facebook, for example, is fair game. So if you have a Facebook page and you put in relationship status single, you know, CIS says that you're going to have a lot of answering to do. Okay, now let's say everything goes well, that you're successful and the officer is convinced that you're a bona fide marriage. Then the I-551, which is the legal term for the green card, will be mailed to the foreign national within weeks after approval. Okay, next slide, please. But of course, it doesn't always go well. So if the USCIS officer is not satisfied with the responses or the documents that were submitted in the initial interview, they'll call for what's called a Stokes interview. And this can be pretty scary because this is, you know, much more formal. This is really your last shot at proving to CIS that this is a legitimate marriage. And it's going to be recorded. So that's in and of itself a little intimidating. And they're going to separate the couple, and the officer is going to ask the couple basically the same questions and compare answers. Now, an attorney is permitted to be present during the questioning of both spouses, and the questions are going to look very closely at the relationship, the history of the relationship, the living arrangements, the daily interaction. They could ask questions like, you know, do you have your house keys, and can I see them, and then compare them to the spouse's house keys. They're going to be looking very, very closely at whether this is a true marriage. Okay, and at the end, they may approve the I-130 if they're satisfied with the marriage, but they may not. And then they may ask the petitioner to withdraw the petition. And if somebody has filed a case and they know, you know, in their heart that it's not a bona fide marriage, they really ought to consider this option because an I-130 is a sworn document, and lying on it is a form of immigration fraud, and marriage fraud in particular is a permanent bar from the United States. Okay, next slide, please. All right, we have a poll question. Okay, Maria, a foreign national, and Paul, a U.S. citizen, are a married couple that file an I-130 and I-485. At the CIS interview, the officer asked if they had any evidence to establish the bona fides of the marriage. The couple hadn't brought anything with them. The officer asked Paul to provide the names of Maria's parents. He couldn't remember. She asked Maria about the date of the marriage. Maria gave a date that did not match the petition. What is the officer likely to do in these circumstances? Okay, next slide. A, deny the case. B, call Paul and Maria back for a Stokes interview, this time separating them for questioning. Or C, issue a request for further evidence asking for additional documentation. Okay, so to recap, Marie and Paul, the married couple, go to the CIS interview and they don't do real well. They forget to bring any kind of bona fide documents. They answer in ways that are not consistent with the petition. In general, things don't go well. So what is the officer likely to do? Okay, so we can close the poll. Okay. Okay. I'm just looking for the percentages. Okay, deny the case. 15% of you answered that way. That's not likely. I guess it's not entirely impossible, but it's not likely. Because you know, they want to give you another chance so that if they're reviewed, they can say that they, you know, gave you the benefit of the doubt and every opportunity to present your case. Okay, B, 70% of you said this, and that's good because it's a correct answer. Call Paul and Maria back for a Stokes interview. And C, 14% of you answered yes, answered C. Now C is also a correct answer. There's a possibility that in addition to the Stokes interview, they will also issue a request for evidence. Okay, Noemi?
All right. When a case is approved, a marriage case is approved, immigration has a system of still being able to check on cases that are based on marriage. So depending on how old your marriage is, there are two types of permanent residence. If at the time of the approval the marriage is younger than 2 years old, the foreign national will get what's called conditional permanent residence. Conditional residence. If the marriage is existed for more than 2 years, the foreign national will get the full permanent residence. Conditional residence means that that residence is valid for only 2 years, and sometime before the end of 2 years, 90 days before the end of the 2 years, the spouses must again file a case with immigration, and that's an I-751 petition asking that immigration remove the condition to that residence status. Next slide, please. That I-751 petition is filed with the USCIS. Typically, it's if the couple are still together and nothing has happened to that marriage, it's filed jointly. Waiver of the joint filing under certain circumstances obviously could not file with a spouse if the spouse is now deceased, or if the marriage has been terminated through divorce or annulment. In that case, the foreign national, the conditional resident, will have to show that the marriage was bona fide when entered into. A third exception to the requirement to file jointly is that the conditional resident has been battered or subjected to extreme cruelty and therefore is no longer residing with the U.S. citizen or green card holder spouse. Or, lastly, it would constitute extreme hardship for that foreign national to have to return to his or her country of origin, to have to leave the United States. So, in order to support that I-751 petition, couples should, of course, save all the documentation they can after the case is granted to show the continuing bona fides of the marriage. And that would again include bank statements, photos of their travels, photos of their families, any financial evidence such as contracts for jointly purchased cars, credit cards, bank statements, etc. That I-751 is filed with the USCIS, as I said, and when the USCIS receives it, it will send a receipt notice to the conditional residence, which will extend his or her conditional residence for 1 year, meaning that with that receipt and with the conditional residence card, the conditional resident can continue to work and continue to travel. Often there is no interview for the I-751. There may be a random audit that will cause the interview, or maybe the immigration will have a question or two based on the documentation and schedule an interview. When the I-751 is approved, the condition is removed and that foreign national is deemed to be a legal permanent resident as of the date of the initial grant. So that time that they were in conditional residence is deemed to be just like being a regular permanent resident, and that time can also be included for purposes of counting towards naturalization requirements of permanent residence.
Okay, thank you so much, Noemi, for that, and I want to thank Noemi and Victoria for that presentation. We're going to go into our question and answers now. A lot of attendees have sent questions, and we appreciate that. And I'm going to turn it over to Victoria, who's going to read and answer our first question.
So the first
Victoria?
question, yes, I'm here. The first question is an arranged marriage considered sufficient for USCIS to meet the bona fide marriage requirement? Okay. Can undocumented individuals and out-of-status individuals file for a green card based on marriage? So that's actually two questions. So let me take the first part of it. An arranged marriage, now I've never actually went to CIS with an arranged marriage, but the whole thing is whether the marriage was entered into for not solely for immigration purposes. So CIS doesn't really care about the origins of it in terms of customs. So if a particular country or group of people have a custom of arranging a marriage, and that's a real marriage, and these people are going to get married and spend their life together, that's fine. That's a bona fide marriage. And then the second question is, can undocumented individuals and out-of-status individuals file for green cards based on a marriage? Okay, they can. Now, if out of status, there's really two groups of people we're talking about. Undocumented, let's assume that does mean people who entered without inspection. They can file for a green card through marriage, but they're going to have to go to the home country to do consular processing to get the green card, and that could be problematic because consular post decisions are unreviewable, and then if they get there and the green card is denied, they may not be able to get back. You can file for a waiver, but that goes a little bit beyond the subject here, the subject of the webinar. But that is a possibility, although a much more complex one. Now, if somebody is out of status, meaning they entered in lawful status and the status expired, then they can still file for a green card based on the marriage, and they can adjust here in the United States without being forced to go home and consular process. Okay.
Okay, so I want to chime in a little bit on that. First of all, for a green card holder, if they've maintained, even if they came in legally, but they overstayed their status or they've worked without authorization, they cannot adjust their status here. The only ones that can adjust their status here who entered legally and overstayed their status or work without authorization are spouses of U.S. citizens. However, as I mentioned in my presentation, if they're eligible under 245I, which goes beyond the scope of this conversation, then on either case, they can file for adjustment.
Okay. Thank you so much. I just want to go over that for a minute because we did receive, thank you for your answers, and I just want to reiterate a couple of things, as we did receive several questions about this. So it does seem to be concern for people. So as Victoria and Noemi said, for someone who's here undocumented, which typically means the person has entered without inspection or a visa, so they've come across the border or they've entered the United States and they never received a visa to come here, that person cannot adjust status in the United States, whether they're married to a U.S. citizen or someone who has a green card. There is an exception, as Noemi mentioned, for someone who's eligible under 245I. And that is an exception to the law that dates back to 2001. A petition had to be filed on the person's behalf by April of 2001. If you think that you qualify for this exception, you should go and speak with an immigration attorney. You would never want to file based on the exception if you're undocumented without reviewing it with an attorney, because it is a complex issue. So, but that's the general rule. And someone who's undocumented cannot apply for adjustment of status. Now, there's another exception to that. A person who entered with the visa, so they were inspected and admitted, and they've entered with the visa, but they have overstayed, so now they're out of status, meaning they've entered with the visa, and for whatever reason, they've stayed longer than they were permitted to be here. So if they entered with the B2, and they were only supposed to be here for 6 months, and they've stayed for 2 years, then they're permitted to file for a green card only if they're married to a U.S. citizen, so not a green card holder. So there was a scenario of a question that an individual was an overstay and they had gone to an immigration attorney, and the immigration attorney had said that they can only file once the spouse becomes a U.S. citizen because he's now only a green card holder, and that's correct. So those are the rules for adjustment of status. Now, if anyone is undocumented, has entered without inspection, or have overstayed, we would all recommend that you speak with an immigration attorney or an immigration accredited representative or contact the CUNY Citizenship Now Center to get advice. You should never file a green card application if you're any of these 3 types of individuals without getting some legal advice, just to be sure before you put yourself out there with immigration. So I hope that clears that up. And let's move on to Noemi with our second question. Noemi?
Okay, thanks. The second question I got is, how long does it take to get a green card once filed based on a marriage to a spouse? Well, I'm assuming here for this question that the marriage is to a U.S. citizen. Well, like I said, that I-130 petition can be filed at the same time as the adjustment of status application, the I-485. And assuming immigration doesn't ask any questions with a request for further evidence, it's typically taking about 3 to 4 months to get an appointment to get the interview appointment in New York. I think New Jersey, I'm pretty certain it's pretty much the same, and I would imagine that it's pretty much the same throughout the country. So it's about 3 or 4 months, and at the interview, they won't give you the approval now, but they'll tell you, you'll hear it in the mail, and my office, we've been getting the approvals within 2 or 3 days after the interview.
So you're saying, Noemi, that someone based on a U.S. citizen once filed could get a green card within a year, most likely. If there's no issues, they don't have to get called back for a second interview. They don't have a request for
no, it's much less than a year. Is that what you said, Patricia?
Okay.
No, much less than a year. It's working much faster, which is why in my office we advise our clients to get their documentation in order as quickly as possible, as to the bona fides of the marriage, because that interview is going to come very, very quickly.
Okay. And I think that's a great rule, but just everyone to know out there that processing times change. So even though it's working very quickly now, 6 months from now it could slow down. So you should always verify processing times, and you can do that on the CIS website. And also, that's if the case goes through very quickly. So that's if the person doesn't get a request for further evidence or an RFE once it's initially filed. That's if they're called for an interview and then they're not called back for a second interview or a Stokes interview, or if they don't then receive another RFE. So that's general processing if there are no things that delay the application. Of course, if there's a Stokes interview or if there's an RFE, that can really delay the processing for several months at least. So I hope that answers that question. And now I'll go to Victoria for our third question from the audience. Victoria?
Okay, the question is, why is the Form G325A required? Okay, so I'm going to ask Noemi and Pat for help on the historic reasons, because I'm not exactly sure why, but I can tell you that what it is a biographical data form. So it asks all kinds of questions about the person, both about their parents, and so that CIS can know what the parentage is, which goes to citizenship and will stay with them. This G325A will stay with them as they go through the system. So if they go to naturalize at some point, all of the statements that they made on that form are going to be looked at. They ask questions about your employment history within the last 5 years. So it's gathering a lot of very useful information and information that they're going to check on later. Noemi, do you want to chime in on why they require this form?
Well, it used to be that the form had 4 copies to it, and one form would be sent to the FBI, the other form to the consular post where the foreign national obtained his or her visa. I don't think they do that anymore because of everything. The checks are done by computers. But I also noticed that examiners at the 245 interview, at the marriage interview, use that biographical information to ask questions of the other spouse. They look at the one G325 of the wife and they ask the husband, what is your wife's name and where did she live before she moved in with you? So that G325, as far as I'm concerned now, is really just for gathering of information.
Yeah, I agree. I mean, you definitely see sometimes during an interview, you'll see an officer with the G25A in front of them, and you have to submit 2. So you submit one for the U.S. citizen or the LPR, and then you submit one for the applicant. And you'll see the officer comparing and saying, what's his mother's name, what's her birth date, and they definitely use that for that reason. Besides the fact that they just want background information for the applicants to see where they've lived and where they've worked. You know, work is a big thing so the person doesn't become a public charge. But I think it's also used to determine the bona fides of the relationship. Okay, and that's a great question. This is going to be our last question.
I just want to add that before, when the G325 was sent out to all these other agencies, it required 4 copies. And you know, I have colleagues who are still doing 4 copies, where there's no sense to having 4 copies anymore. Just 1 copy of the G325 is enough.
Right, absolutely. I think even the form now, it's only one. It's only if you
Okay.
go online to. I mean, some people, you know, people have their own form systems. But if you go online to the USCIS website, it is only 1 copy now. I remember, I don't know if ladies remember, but when it was a carbon, and that was a nightmare. But anyway, so now we have a question regarding a couple who's married and they have a child, and a green card application's been filed, and they have an interview coming up, and they're actually separated. And the question is whether or not the adjustment will be denied. And you know, this is an interesting question because they're technically still legally married. So as long as they can prove it, Victoria had touched on this in the beginning when she was talking about the legal standard for marriage cases. It says as long as you can show that initially the inception of the marriage, that it was bona fide, and as long as show that the marriage is still valid, meaning that you haven't been divorced, a separation does not necessarily mean that the application will be denied. Now, of course, if you are separated, the officer will probe, and they may probe a little bit deeper to see what the reasons are for being separated and to make sure that the inception of the marriage is bona fide. But in this case, the fact that there is a child together is definitely evidence that the marriage was bona fide. Victoria or Noemi, do you have anything to add to that?
I think it helps that they were also married for 5 years, so it wasn't like a fleeting marriage that, you know, as soon as somebody got the green card, that was it. They called it a day.
True, true.
Yeah, and I just want to say that, you know, yes, it helps to have children, but for many officers, having children is not dispositive. I've heard many times anybody can have children.
I mean, that always amazed me. That, you know, I'd have a couple that have a child together, and the birth certificate has both names, and the officer would almost just not take it as evidence. But so yes, that is definitely a great point, Noemi. That just because someone has a child is not dispositive. So the fact that you're separated will definitely be probed into whether or not the marriage is bona fide. So this is going to be our last question, and it's regarding 751. And the question is that once the 751, the question is, once the 751 is approved, the foreign national status is extended for a year. That's actually not true. What happens is, once you file the 751 to remove the conditions from a person's green card status, once you're sent the receipt notice, and this is what Noemi had talked about, once you're sent the receipt notice, your status will be extended for a year. And the reason why immigration does that is because they don't want your status to expire while they're processing your 751. So with your expired green card and with the receipt notice, your status will be extended for a year. But once your 751 is approved, so whether you're called for an interview or not, once you get that approval and you get your permanent green card, you're done. You're a permanent, lawful permanent resident, and you no longer have any conditions on your green card as far as your marriage. I mean, people who have green cards have conditions, which is another discussion as far as keeping their residency for naturalization purposes and just keeping the residency, but regarding the marriage, you're done with the 751. And the next step would only be to file an I-90 once your actual green card expires in 10 years. Do either of you have anything to add to that?
Well, given that this is Citizenship Now, when somebody's married to a U.S. citizen and living with and having a green card for 3 years and living with that citizen for 3 years, they can qualify for naturalization. Now, if you file that I-751 and it's still pending and you already have the 3 years, you can also file for naturalization, and the I-751 and the naturalization application will be adjudicated at the same time.
Yeah, that's a great point. I mean, that's definitely, I mean, this is outside the scope of this group.
Right.
That's a great tip from Noemi, is that, you know, your 751 will be filed 2 years after 2 years of being married, but then, you know, a year later, you're going to, well, if you choose to, not everyone has to naturalize. You have to file a 751. If you do not file a 751, your green card will expire, and you might actually jeopardize your status in the United States if you do not file a 751. It is mandatory if you're going to remain here. No one's required to file for naturalization, but you are eligible a year later, as Noemi mentioned. Okay, I think that we're done with the question and answers. I want to thank Victoria, Donahue, and Noemi Slea for their wonderful presentation today and the question and answer period. We can move to the next slide. So I wanted to tell everyone that today's web seminar is recorded, and you'll receive an email with instructions on how to access the seminar and related materials after the presentation today. We can move to the next slide. There are a bunch of people we want to acknowledge, and those people are listed here. We could move to the next slide. So I want to thank everyone again for being here, and I know we got to a late start, and I apologize for that, but we did go through all of the presentation, and the speakers were very thoughtful in their words about the topic, winning a marriage case. But there may be some questions that you weren't able to get to us, or you may have some questions that go unanswered. If you have further questions regarding the information presented today, please feel free to contact me, Patricia Wonder. My email is there for you, patriciawonder@johnsonwonder.com. I want to thank CUNY Citizenship Now and CUNY SPS for sponsoring this webinar today. I also want to remind you that our next webinar will be in February, and it will be February 17th, and it will be regarding adjustment of status. So there'll be some discussion similar to what we talked about today, but it'll be more general. So for everyone applying for adjustment of status. So if you have an interest or you have some questions that you would like answered, please feel free to register and join us on the 17th. And please tell your friends and neighbors. I want to thank you again. Thank you so much for joining us.